Wait, please, Lordship. Lordship, this matter had come up on Friday also. Lordship, there's a delay of 30 days in preferring the appeal.
Okay.
So,
Okay. Who's for the other side? No one.
notice has to be Lordship.
What is this?
This is an appeal against the order passed by the special court, Mia Court, Lordship, releasing the respondent on bail.
Okay. Do we issue notice? Alright, Miss Mr. R.K.D. Chaudhary, then Deputy SDF, who submit that there is that the delay of 30 days in filing the appeal should be condoned. List the issue notice returnable in 4 weeks. Appellant to take steps, applicant, is it?
Yes, Lordship.
The IA, applicant to take steps for service of notice upon the respondent by registered positive respondents
Yes,
within 3 days.
obliged, Lordship.
Leaves the matter to court.
My lord, actually, I make a sincere regret because I could not present yesterday because of present in court number 1. So far, my case is concerned, my lord, we have filed
This is
IA for bail in
IA.
the pendency of the appeal. Now, my lord, at present, my lord, I am urging for bail. Now, what are the points for granting bail? I will show your lordship. This judgment appears to be a moral conviction.
Huh?
It appears to be a moral conviction. The conviction is not founded with sound evidence, law of evidence, and other criminal law. For instance, I am showing certain portions. Kindly take up criminal appeal number 34222. Some
Yes.
portions I am drawing your lordship attention. Page 19, can you see?
Yes.
Page 19, para 10. In her cross-examination,
Page 19.
page 19 of criminal appeal,
Page 19. IA. In the IA?
not criminal appeal. For granting bail, I am drawing lordship attention to criminal appeal.
I've got 342.
This is not 342. It's 342. It's 19.
19.
Okay, yes.
Normally, it was the case of the informant that the girl was minor and she was subjected to offense under section 6 of the POCSO Act. Now I draw your lordship kind attention. Para 19, in her cross, she deposed that none of the villagers informed.
What is his? He also does not know anything. Correct.
He is also only know that they both are friends, accused and accused are friends, and they work together for a painting purpose, and they have a good relation, are nothing any enmity before Priorities Act, Priorities incident, and all accused person along with deceased person and along with PWT have taken alcohol in her country work,
Okay,
the
then
house of
PW6,
PW6 is the mother of the accused, a deceased lord.
mother of,
Deceased. Deceased lord. And married.
this,
I know accused Manjeet Sarkar, who has been present in the accused talk. The house of accused Manjeet Sarkar is situated about 1 kilometer away from my house. The accused Utpal Sabukdara was my son. That is, the accused Manjeet Sarkar and my son Utpal Sabukdara was classmates. And taking this clue, the accused Manjeet Sarkar used to come to my house off and on. My son Utpal Sabukdara was a painter. The accused Manjeet Sarkar sometimes used to help my son Utpal Sabukdara in his painting work. The occurrence had taken place on 25/2016 at about 4 p.m. in the homestead of Letu Lohar. The house of Letu Lohar is situated in my place, but to some distance from my house. At the time of occurrence, I was in my house. On the date of occurrence, soon after the occurrence, Srimati Dipanjali Lohar, the daughter of Letu Lohar, came to my house and stated that in their homestead, the accused Manjeet Sarkar had given blow with a dagger upon the person of my son Utpal Sabukdara, and Utpal Sabukdara was about to die and asked me to come to their house. Instantly, I ran to the house of Letu Lohar and found my son Utpal Sabukdara had been laying in a pool of blood in front of the house of Letu Lohar with injuries over his neck. Then my son Utpal Sabukdara stated to me that the accused Manjeet Sarkar had assaulted him with a knife over his neck. My son also stated to me to look after his son. My son also stated to me to provide him water. Then I found some water in a receptacle and I poured some water into the mouth of my son. Then I raised shouting to save my son. Then the local people assembled. I took my son into my lap. Thereafter, an ambulance came, but my son had passed away before he was taken into the ambulance. In his course, she also admitted that after about half an hour, I reached the place of occurrence, had stated the occurrence.
yes, that their dying declaration and that she also gave water to him.
Yes,
My son also stated to me, my son also stated to me to provide him water. Then I found some water in the receptacle and I poured some water into the mouth of my son.
yes,
Okay, so, but then in the cross, he said that it is known to me that deceased and appellant used to take alcohol together.
yes,
So they are friends.
yes.
Then PW7,
PW7 is the doctor. On 21/5,
let us see the opinion of
opinion.
that. More detailed description of thing, page 24.
Yes, a stab
Okay.
and penetrating
Yes,
wound up
okay,
into
so
the
that is
right.
there. Then let us go to the next one, PW8.
PW8 is IO of the case. Sushil Kumar Bhuyan. On 15/5/2016, I was working as IC at Chimboliguri police outpost under Bigpura police. Okay.
Knife was plotted with blood.
On that day at about 4:45 p.m., I received a mobile phone call from Sri Dulu Bosumotari, son of Sri Soilen Bosumotari of place Nang 3 Simbolguri, wherein he stated that in the courtyard of Sri Letu Lohar, a boy of their place had committed murder of Utpal Sabukdara, and after committing murder, the boy fled away. On receiving the aforesaid message of mobile phone's call, I made a GD entry of same by Chimbolguri outpost, Chimbolguri police outpost GD entry number 322, dated 25/5/2016. Thereafter, I, along with my police staff, went to the place of occurrence, which is the homestead of Sri Letu Lohar of place 3, Chimbolguri. When I reached the homestead of Letu Lohar, I found a dead body had been laying in a pool of blood in the courtyard of house of Letu Lohar, and many people had been gathered there. Sri Letu Lohar and other people gathered there stated that the dead body was of Utpal Sabukdara. Then I prepared a sketch map of the place of occurrence. Exhibit 4 is the sketch map and of the place of occurrence. Exhibit 4.1 is my signature. In it, by the side of the dead body of Utpal Sabukdara, I found a knife clotted with blood. Sri Letu Lohar stated that the accused Manjeet Sarkar had committed the murder of Utpal Sabukdara in his courtyard. I also found a jar made of steel. situated by the side of the dead body of Utpal Sabukdhara. Then I seized the knife and the jar made of steel by preparing a scissor list. Exhibit 2 is the scissor list and exhibit 2 is my signature. I did not find the accused Manju Choka in the place of occurrence as he has fled away. Thereafter, from the place of occurrence, informed the occurrence of to the OC Bipuria Police Station. The OC Bipuria Police Station within half an hour came to the place of occurrence. Then OC Bipuria Police Station stated that on the way to the place of occurrence from Bipuria Police Station, he along with his staff caught the accused Manju Choka as he had found on the way and forwarded him to Bipuria Police Station. Thereafter, I performed inquest upon the dead body of Utpal Sabukdhara. The original inquest report is not with the case record. Thereafter, I recorded a statement of witness under section 161. Thereafter, I took the dead body of Utpal Sabukdhara along with me for postmortem examination. As the night came down on that day, I kept the dead body of Utpal Sabukdhara at Bipuria Police Station. On the same day, 25/2016, an Azahar was lodged by Munindo Sabukdhara with Chimolguri outpost. Regarding the occurrence, I made a GDNT to the Azahar of the Azahar by Chimolguri Police Outpost GDNT number 327 dated 25/2016 and forwarded the same to the OCPS Bipuria Police Station to register it under proper sectional law. Accordingly, OC of Bipuria Police Station registered a case by Bipuria Police Station case number 328/2016 under section 302 of IPC and trusted me with the charge of investigation of the case. On following day, 21/5/2016 in the morning, I forwarded the dead body of Utpal Sabukdhara to North Lakhimpur Civil Hospital for postmortem. On the same day, the postmortem examination upon the dead body of Utpal Sabukdhara was conducted at the North Lakhimpur Civil Hospital. And after postmortem examination, the dead body of Utpal Sabukdhara was handed over to the guardian of Utpal Sabukdhara. On the same day, I forwarded the accused Manju Choka before the court. Thereafter, I collected the postmortem examination report of Utpal Sabukdhara from North Lakhimpur Civil Hospital. After completing the investigation of the case, I find sufficient incriminating materials against the accused person Manju Choka under section 302 of IPC, and accordingly I submitted the charge sheet against the accused Manju Choka under section 302 IPC. Exhibit 5 is the charge sheet. Exhibit 5(1) is my signature in it. The seized knife and jar made of steel has been produced before the court. Materials exhibit 1 is seized knife and materials 2 is the seized jar made of steel. In a cross-examination, he also stated that at the time of occurrence, the accused Manju Choka, deceased Utpal Sabukdhara and owner of the house Letul Lohar were taking alcohol along with green mango. Page 27 last row.
What about 313? Anything there?
Yeah, he said that it was only pushing. I did not cut the neck.
Where in Tara?
Yeah.
Question number?
Lordship will go to page 31. Answer to the question number 3.
Yes.
Otherwise, he has admitted they were all, three were there, they
Yeah.
were taking alcohol and all.
Question number?
Question number 3. It is not true. I had not given any blow with the knife.
Yes, yes, let him finish.
Yes.
Yes.
Anything else?
This taken place only in the intoxicated position of accused person and deceased person. There is no such intention or motive to kill the accused or deceased person, Lordship. And from the evidence on the side,
But the problem is whether intoxication can be an alibi. Can it be used?
Lordship.
Whether intoxication, look at 86, 89, what is it?
Yes, it starts with 82. General acceptance.
86. Please read section 86. IPC.
Things done in 86.
86. Wait, no. Yes, 86.
Offense requiring a particular intent of knowledge committed by one who is intoxicated. In cases where act is done is not an offense unless done with a particular knowledge or intent.
No, 85.
Act of a person incapable of judgment by reason of intoxication
Yes.
caused against his will. nothing is an offense which is done by a person who, at the time of doing it, is by reason of intoxication incapable of knowing the nature of that act, and that he is doing what is either wrong or contrary to law, provided that the thing which intoxicated him was administered to him without his knowledge or against his will.
So 85 cannot be a defense. Because that drinking of alcohol, it was not forced upon you. You willingly took it.
But in the evidential, in the point of evidence, all evidence stated that both all are the deceased and the accused person are friend, their best friend, their classmate. They
But
have
that is
no
a
such
different
an
thing.
enmity earlier.
But what you see, that's a different thing. But as per section 85, if you commit a crime, you cannot take the defense of saying that you were intoxicated, you were drunk, unless that thing that made you drunk was given to you forcefully. So here you had willingly gone with mangoes, green mangoes, and that stainless steel, whatever jar, and then you ask for salt, knife, having the mangoes only without salt might be difficult to have.
Green mangoes.
You should have asked for chili also, actually, green chili.
Judgment, some
Anyway.
tamanna,
So the thing is, Mr. Counsel,
regarding intoxicated conditions.
yes, please give us. No, but then you see one thing, the section provides that defense can be used only if you take that alcohol or whatever, if it is forcefully given to you. Here you have willingly taken it. That is the problem. Whether that issue has been settled there, you know. Which para?
Para 16, page 80.
Citation. Citation.
Yes.
It's not reported.
Para 16.
Yes, Lord. In view of the above discussion finding, we are of the firm opinion that the appellant is beat of person and being under influence of alcohol acted in a manner that he knew is likely to cause death of Lakshmi, but without the intention to kill her.
No, that is all right. That is heat of passion. What you are talking about exception 4 to section 300.
Yes, Lord.
Now for exception 4 to 300,
Exception.
Action 4 to 300, Lord.
exception 4 to 300 would require that it was done in the heat of the moment. Plus there is, I think, another,
To submit is, if your lordship goes to all the ingredients of the fourth explanation, it will be difficult to bring this case within its,
within four.
but yes, but without going into, of course, there are statements that there was a quarrel. And 161 I have seen of Letu Lohar, he said that they used to paint together. So there was some.
No, mother
altercation.
also says that they drink together.
No, they used to paint, they were painters. So regarding some money, one was supposed to get some money from the other and there was an altercation.
Because of the drinks, most
And
probably.
drinks was there.
They were there. So they came together to have a good time with mango, everything.
Yes, but it resulted in
And
such.
resulted, there was
Yes.
no premeditation, nothing. It
He in his 253, I think, statement also, he said that I had no intention. Lordship will go to the last answer.
313.
Even to the last answer to the question, page number 36,
313 statement.
313. 313,
Page.
page 36. Page 36, the last but one question.
Yeah.
I had not committed murder of Utpal Chabukdhara with my conscious knowledge. And even in his statement on sentence, he had said, if I caused the death of Utpal Chabuk, it was not with my intention to cause the death. The next page, 37. It was done under the influence of alcohol. And there is nothing to disbelieve the eyewitnesses. Both the eyewitnesses,
This is sentence hearing.
this is sentence hearing.
Will somehow, I think, why won't why won't the fourth exception be applicable?
Yes, yes, lordship can apply because there was a quarrel without any
There
premeditation,
was a sudden, in the heat of passion,
Ah.
while with
of passion.
drinks,
drinks and everything.
everything was, added to it.
Now,
And there's nothing otherwise.
homicidal death committed
How
with
long
this
has he been in jail?
No, I have taken it out. He was arrested on 21/5/2016. Then he was granted bail after 3 months. On 19/8/2016, he was granted bail.
Then when did he go? in?
Then he was again arrested on 13/8/2016.
31?
13/8/2016. Perhaps he did not appear and
No,
non-bailable
no, you
warrant
see,
was issued.
21/5/16 arrested.
Yes,
Bail granted when?
19/8/16.
19/8/2000. Then arrested when?
Again, he was arrested on 13.
13? How can it be 13?
Oh, cannot be.
How can
No,
it?
no, this is 2018. 13/8/2018.
Arrested?
Yes. He did not appear and non-bailable warrant was issued.
Okay, then he's been there since then.
He's been there since 18.
Since 18
Hmm.
till now. That
Till
means for around 5 years.
4 years something.
Yes, Lord. Yes, Lord.
Okay,
Lodge.
heard. You're the amicus?
Chief Upang.
You're amicus?
Amicus? No, general appeal. No.
General Appeal.
You're okay. Heard, Mr.
Chief Upang.
G. Foucault, learned counsel for the appellant. Also heard Miss S. Jahan, additional PP. This appeal has been filed against the judgment and order dated 22/11/2019, passed by the Sessions Judge Lakhimpur in Sessions Case number 143 bracket NL/2017, by which the appellant has been convicted under section 302 IPC. Acha, wait, you say judgment, huh? Judgment is of judgment, okay. And sentenced to undergo rigorous imprisonment for life with a fine of rupees 5,000, in default, rigorous imprisonment for 6 months. Yes, sir. The prosecution case in brief is that one Munindra Chabukdara, who is PW1, PW2,
P22.
had filed an FIR dated 20/05/2016 before the in-charge Simaluguri Police Outpost, stating that around 4 p.m. on 20/05/2016, Shri Manjil Sarkar, Manjil or Manjit?
Manjit Sarkar.
Manjit.
Babu.
Manjit.
Manjit. Alias
Shri
Babu.
Manjit Sarkar,
Alias Babu.
alias
Babu Sarkar.
BAPU, Bapu Sarkar,
Babu Sarkar.
had called his elder brother Utpal Chabukdara to the house of Sri Letu Lohar, bracket PW 3. Full stop. Thereafter, thereafter liquor was provided to his elder brother and Shri Manjil Sarkar bracket appellant killed his elder brother by stabbing the deceased with a knife. With a knife. Full stop. Next para. Pursuant to the FIR dated 20/05/2016, Simalu Guri PS case number 328/2016 under section 302 IPC was registered and investigation was held. Full stop. After investigation was complete, the IO submitted a charge sheet on finding that the prima facie case under section 302 IPC had been found against the appellant.
Your Lordship.
Huh?
Vipuria case number.
Huh?
Simboluguri is out of police station.
Outpost.
Outpost.
I said outpost. Acha.
Yes, Vipuria police PS. Register number 328.
Acha. Acha, not Simalu, it's Bihu Puria PS case number. Earlier when we say outpost, you say under Bihu Puria police station. Next. Charge was framed under section 302 IPC, to which the appellant pleaded not guilty and claimed to be tried. Full stop. Next para. During trial, 9 prosecution witnesses were examined by the learned trial court. Full stop. Thereafter, examination of the appellant was done under section 313 CRPC and consequent to the above, the impugned judgment and order had been passed by the learned trial court. The learned counsel for the appellant submits that a perusal of the evidence shows that there were 2 eyewitnesses to the crime. He submits that though the evidence points to the fact that the appellant had taken the life of the deceased by stabbing him on his neck, the said act was not done intentionally and neither was it premeditated. He submits that the evidence recorded by the learned trial court shows that the deceased and the appellant were friends and that on the date of the incident, the 2 friends had gone to the house of PW3 to have liquor and green mangoes. During the drinking session of the liquor, PW3 had also joined the deceased and the appellant. However, due to a quarrel that had ensued between the appellant and the deceased, and in the heat of the moment, the appellant appears to have stabbed the deceased in his neck. The learned counsel for the appellant thus submits that as the present case attracts attracts exception 4 to section 300 IPC, the appellant could not have been convicted under section 302 IPC. So he submits that the appellant should have been convicted under part 2 of section 304 IPC. Next, Ms. S. Jahan, the learned additional PP, fairly submits that the evidence of the prosecution witnesses and especially PW3, in whose courtyard the appellant and the deceased were drinking, goes to show that the appellant and deceased were friends for a very long time. She also submits that the evidence of the mother of the deceased, that is PW number 6, also shows that the deceased and the appellants were friends, and that there was no enmity between the parties. She also submits that there is nothing to show that the act of the appellant had been done intentionally,
Premeditation.
had been done with any premeditation. And as such, and as such, there could be some substance in the submission made by the learned counsel for the appellant. That's all. We have heard the learned counsels for the parties. As can be seen from the evidence adduced by the prosecution witnesses, the appellant and the deceased had carried liquor, country-made liquor, in a steel jar to the house of PW3. PW3 thereafter laid some chairs in the courtyard of his house and also brought out knife and salt. That's all.
Chili.
Knife, salt, and chili, to enable the appellant and the deceased have their drinks and the green mangoes that they had brought. PW3 also joined the appellant and the deceased while partaking of the country-made liquor and the green mangoes. However, as per the statement of the eyewitnesses, that is PW1, who is the daughter of PW3, and the statement of PW3, a quarrel ensued, and thereafter the appellant stabbed the deceased in his neck. comma, due to which the deceased died, comma, as can be confirmed from the opinion of the doctor, bracket PW number, PW7, comma, who in his evidence states that the cause of death was due to hemorrhage shock as a result of the perforation of brachiocephalic artery, which is antemortem in nature. That's at page 24, huh? Page 24. Full stop. Next. The evidence of PW number, PW2, who is the brother of the younger brother of the deceased, and who was the informant, is to the effect that his brother had made a dying declaration before him that the appellant had stated that the appellant had given him a blow with a knife on his neck, had stabbed him on his neck. This is it. If we use the word blow with, how can there be a blow with a knife? Stabbed with a knife, huh? Full stop. The evidence of PW6, who is the mother of the deceased, is to the effect that her son was to the effect that the deceased told her that the appellant had assaulted him with a knife on his neck. Full stop. Further, as his son asked her for water, she gave some water to him in a receptacle and poured it into the mouth of her son. Full stop. PW6 also states that the appellant and the deceased were classmates, and that the appellant used to come to their house very often. Used to come to their house off and on, off and on. She also states that the deceased was a painter and the appellant used to sometimes help her son in his painting work. She also stated that the appellant and her son, the deceased, used to take alcohol together. The evidence of the IO PW8 is that he had seized the knife which was clotted with blood. He seized the knife which was used for the offense and which was clotted in blood. He also seized the seal jar in which country liquor had been taken by the appellant and the deceased. to the house of PW3. Next. That's all I think. On considering all the above statements made by the prosecution witnesses, comma, which has not been shaken during cross-examination. We find that while the appellant had caused the death of the deceased by stabbing him on his neck, comma, there was no premeditation on the part of the appellant in taking the life of the deceased. Full stop. Next para. Continue. The only question that has to be decided is whether the act of the appellant would come within any of the exceptions provided under section 300 IPC. Full stop. So I'll give you later on, okay? So just write so hearing concluded, judgment reserved. Basically, you all know where it's going, but you have to correction and this, that.
As far as years is concerned, 7-8 years, I. Part 2.
That will decide.
Lots.
You see, the thing is that there is no premeditation at all. And it was that incident because probably, like you said, there might have been some money issue. Where is it stated?
No, it is in the 161
Oh, was it?
statement. of
And
the
it's
owner.
probably, you see, the money is borrowed sometimes, you know, with the drinks, you go overboard in your arguments and, you know, in
Yes,
your
yes.
behavior.
This is what had happened.
It usually happens.
Usually
So-
happens.
So I think he must be full of guilt now, losing one of his good friends in this manner. So it's quite a punishment in itself also.
Yes, of course.
Mm.
That is it.
Mm.
In his 313 also he said that apart from that no intention part, he said everything happened when we were intoxicated.
We could have given you the final decision now, but then that might not look proper. So reserving it then.
Obliged.
Acha, item, what is the item we took just now?
Item 1.
This matter,
Pause this, okay, item 1.
this is
Bill
not-
application.
yeah, this is not a this is against the judgment, my lord.
Huh?
This appeal is not against judgment, my lord. It's a bail application, madam.
It's against the bail application.
Bail application.
It's against the bail given.
Bail granted to the accused. I'm for the prosecution, madam.
Bail granted when?
Madam, bail was granted in by order dated 1/5/17.
1517.
17,
1517.
2017,
Now nearly 6 years have gone.
6 years ago.
Is, are you still pressing this case?
Benedict Mal.
Huh?
Uh, That happened so, Marat, because the thing happened that accused was not found because he belongs to NSCN category, Marat. It's a matter from Nagaland, Marat.
Maybe.
So accused was not found, so service of notice, it took time, etc. and all this. And that is why the matter got delayed to come up for hearing. Marat.
No, but then has he violated any of the provisions of the bail
Yeah,
condition?
the only factor that.
If that is the case, you go back to the court which has.
That is where we are possibly will your lordship and we can agree upon, Marat. The impugn order, Marat, that was passed, Marat. Actually, that had ought to have been in the form in the category, Marat, that after discussing the material facts, 161 statement and all this thing, and only bail ought to have been granted. But it was done in a cryptic manner. That is where we are, Marat. What your lordship may do, Marat, after crossing the impugn order, Marat, send back to the trial court for rehearing on the appeal, Marat. Rehearing on the bail matter. Your lordship may kindly.
Why should we quash the order?
That is where, Marat. Your lordship may kindly.
And especially after 6 years?
Marat, yeah. Your lordship, that is up to your lordship, Marat. Your lordship may
No,
kindly.
no. So you please answer the question.
Marat.
You see, it's not that you go on a steam
because the-
engine on your own
Marat,
steam.
Because
You've got to ask. You've got to answer the
Yeah,
question
yeah,
posed
but-
by us.
because
So what is the question posed by us?
Yeah. Marat,
No, no. Have you?
I understand, Marat. I'm just answering to that.
Yeah.
Here, UAP Act is involved here. He is affected to UAP Act. Now, in UAP Act, Section 43D(5), it says that if a prima facie case is made out, bail cannot be granted. That is 43D(5). And 43D(6), this condition is in addition to 43, in addition, that double requirement. So, when
Which section? Section 40?
43D(5), UAP Act, you also may kindly just.
Yes. UAP Act.
Yes, UAP Act. UAP Act 1967.
Is it here?
No, but
Supplementary.
UAP Act. Unlawful activities. Unlawful activities Act.
Mr. Counsel, just tell us one thing. When the bail was granted, charge sheet had been filed?
Yes, such as
Charge sheet filed. When was charge sheet filed?
my lord, there are two search sheet. One search sheet was filed on 23/11/15.
23/11/15.
There is a main search sheet and supplementary search sheet was filed where this accused involvement. Fine. আহিব। That's fine. On 14/6/16,
14/6/16,
16,
and bail was granted in 17.
and bail was granted on in the year 17. 15/17. Evidence is going on.
Is going on. Is he coming to court?
He has come to
He's coming to court. Then what remains?
no, because of the pendency of the appeal, Manoj, he has been coming continuously to the court.
So
That is it.
if he's appearing before the trial court and on the court date fixed for trial, what remains?
And your lordship may kindly,
No, why should we go into those aspects now?
kindly look at 43D5.
What is
One
it?
section 43D5.
Yes,
Notwithstanding anything, your lordship, at page 26, I do not know,
page, yes, 43.
D5, clause 5.
The-
Notwithstanding anything contained in the code, no person accused of an offense punishable under chapter 4 and 6 of this act shall, if in custody, be released on bail or on his own bond unless the public prosecutor has been given an opportunity of being heard on the application of for such relief. Provided that such accused person shall not be released on bail or on his own bond, if the court on a perusal of the case study or the report made under section 173 of the code is of the opinion that there are reasonable ground for believing that the accusation against such person is prima facie true. Then that is section on grant of bail stated in section 5 is in addition to the restriction under the code or any other law for the time being in force. So if the accusation is prima facie true, then the hands of the trial judge is
Right.
tight. That way. So let me kindly look at the appeal order. That is a page you will also find 106 of my appeal petition matter. Annexure C.
Who is for the other side?
But notice has been served. He has received the notice, but he has not appeared.
Just a minute, let us see.
He also will.
DK Das, learners obtain inspection and summon. Okay, so he's not appeared.
Let us see the input order.
Yes, yes. Page
106.
1.
Both the counsel of the for the parties present as the matter is fixed for hearing today. The learned defense counsel Sri so and so for the petitioner, the accused A13, that is a volunteer, submits that while incorporating the statement in the bail appeal number so and so, submit that the name of the present accused appears in search sheet only at paragraph 16.27 supplementary search sheet, wherein there is no evidence to show that the present accused is involved in the instant case. There is no direct or indirect evidence to implicate the accused for his involvement in the present case. Therefore, he deserves to be released on this ground alone. Learned so and so submits that the relevant materials in the brief facts of the case in supplementary search sheet at paragraph 16.27, which came on record that accused 13 SS Second Lieutenant NSCNK, close to Senior so-and-so brigadier who was part of conspiracy and assisted in the attack on 19 Assam Rifle personnel at IG Stadium, Kohima on 26/3/15, which led to the death of one personnel of 19 Assam Rifle by the NSCNK cadre. Accused 13 was injured by bullet injury during encounter with the security force, which was by his own admission confirmed by duly constituted medical board at New Delhi on 1/1/16. Prosecution document B19 A19 A13 was accused 13 was carrier of large numbers of arms and ammunition and other materials transported by him and other cadres at the behest of SS Brigadier so-and-so and handed over to NSCNK. Town Commander so-and-so, if accused number 4, already arrested and charged in this case for carrying on subversive activities by the strike team on 26/3/15. Accused 13, along with other accused, para 17.1 of supplementary charge sheet, shows that accused 13 has prima facie evidence against him in conspiracy planning, assisting, taking part of the execution of the attack on personal Assam Rifle, making him liable to be sentenced under section 120, read with 1820 of UAP Act. Submission of synopsis of objection against grant of bail and reliance is placed on Guwahati High Court criminal so-and-so SK Courts, and I have decided on 15/10/15, copy of which on record to be perused by this court on relevant para relied on by the prosecution case for rejection of bail. Hard both the learned counsel for the petitioner NIA at length and peruse the record and the supplementary charge sheet. From the perusal of the supplementary charge sheet, the present accused is charged under various section of law, namely 120 IPC, 18 and 20 UAP Act. It is submitted by the special PP and that the present accused person was part of conspiracy and giving assistance to the group which attacked on 19 Assam Rifle personnel at IG Stadium, Kohima. However, there is no prima facie material or evidence to show the involvement of the present accused in conspiring with the members of the organization or in assisting NSCNK cadres in carrying out the said attack. As such, the allegation of conspiracy under 120 IPC and 18 UAP Act is not prima facie made out. Now, considering that is a mini trial matter here. Now, considering the charges at present accused being a member of NSCNK, which is a banned terrorist organization, the question lies that whether the prosecution can secure the conviction of the accused for being a member of terrorist organization under section 20 of UAP Act after conclusion of the trial. It has been made out that a present accused is a member of NSCNK. However, the active involvement of the accused in furtherance of the offense is not made out. This court is placing reliance on Arup Bhuiyan, State of Assam, so-and-so, wherein the relevant portion are reproduced herein. Mere membership of banned organization will not incriminate a person unless he resorts to violence or incites people to violence or does an act intended to create disorder or disturbance of public peace. Mere advocacy or teaching the duty, necessity or propriety of violence as a means of accomplishing political or industrial reform or publishing or circulating or displaying any book or paper containing such advocacy or justifying the omission of the violent act with intent to exemplify, spread or advocate the propriety of the doctrine of syndicalism or to voluntarily assemble with a group formed to teach or advocate the doctrine of criminal syndicalism is not per se illegal. It will become illegal only if it incites to imminent lawless action. Thus, considering the submission of both the learned counsel and view of the above stated opinion, the and without expressing any final view of the merit of the case, I am of the view that granting bail to the present accused has been made out according to date so and so. Now here you also will find he has formed an opinion here now considering the question lies whether the prosecution can secure conviction of the accused for being member of various organization others can so and so at the time. But that is an opinion he has formed or he has won a mini trial to this case.
Huh?
He has done a mini trial. How can he form an opinion without there being an evidence?
No, but then that is what is required.
No, without forming an opinion, he could have granted bail. But
Just tell us one thing, this Arup Bhuyan, who was state of Assam, is it still holding the field?
No, that has gone to full bench, Mother.
Has it been decided by a larger
no,
bench?
Not yet decided.
Not yet. So
Not
till,
yet.
till it is decided that
And
this
this
law will
case-
hold.
This case is not applicable in this case. You also will find it isn't because this man is injured. He was carrying arms and ammunition and supplying it to AK number 4. So he was an active member. And where in Orguyan's case, there is a different case, Mother. So this case, although it has been cited, Mother, it is not applicable. That is what we
Not applicable.
not applicable.
Mr. Council, one thing, you see, I can understand if you had challenged the order of 2017 at the earliest.
We have selected,
When did you file this appeal?
Mother, we have filed it. We have filed it, Mother.
In the year 2020.
Yeah, 2020.
Yes. After how many years? 3 years.
No, they did. Mother, we have filed it in 27/7 filing number. We have filed it on 27/7/2017.
Hmm?
That is the filing number, Mother. It was registered somewhere, I do not know because
Okay, 17.
was-
Yes, you have filed it as 17. But why is it reflected as 20?
there was a condonation. Condonation.
For donation?
Yeah, there was a delay.
How much
So-
did it?
It was a few days late. That was condoned appeal. And after that, it was registered as an appeal. Those factors are there. Madam.
And you see, right now, already nearly 6 years have elapsed, nearly 5.5 years that's elapsed. This was, order was passed in May. So now tomorrow is going to be March. So May. So 5 years, 9 months have elapsed.
I have seen.
And as on now, whether we should interfere with this order, whether it's right or wrong, that's a different thing. And keeping in view the fact that he has been attending court.
That is what I have got. The order says, Madam, because the court required.
Yes, you have passed, you have brought the orders.
Order says, that is what the order says.
So,
But these are the facts, Madam.
I
These are the
know.
facts.
But then, you see, in the peculiar facts and circumstances,
One of,
whether we should go on into this aspect.
while selling this order, Madam, I was saying that whether the court can assume that when a conviction can be obtained under this section 20 because of he being a member. That is an opinion he has given.
That is an opinion. It's not on the merits of the case. It's just an opinion.
Yeah, so
So at the
That was
time of
I'm-
bail, it's basically on the opinion of the court. It cannot be on the merits. So what is wrong?
but this goes because
You see, bail, just because bail is granted, doesn't mean that he'll become innocent, but then there is a likelihood that he finds that he doesn't appear to be involved. That's what we see.
whether prosecution can secure conviction under section 20, that is a question of evidence.
Correct. That,
That you also will take care of.
okay. That observation
That you also
will not be considered to be a finding
yeah.
on the merits of the
Yeah,
case. That's what you want this court to say.
Yeah.
Is it?
And
So this, whether the observation made by the trial court
yeah, two parts.
that whether conviction can be made,
obtained,
can be obtained.
obtained on a question of this, he being a member of a terrorist
Correct,
organization.
correct.
Another observation, my lord,
Yes,
that as such, the allegation of conspiracy under 22 is not prima facie made out.
where?
At page 108,
Yes,
at page 108, the
Yes.
first, that is before now considering before that,
before
Uh,
that,
as such,
as such.
the allegation of conspiracy under section so and so is not prima facie
Okay,
made
so
out.
we'll just say this
These are-
observation will not have a,
These are two peering matter
Ah.
that may pose a little difficulty on the prosecution. The lordship will take care of.
heard,
Step by
yes. Heard Mr. D.K. Das, learned senior counsel, assisted by G.D. Chaudhary. For the appellant, is it appellant? Appellant. Yes, sir.
If your lordship wants, the FIR is at page 32. Page 32 is the FIR, if your lordship,
Page 32.
32.
The present appeal has been filed against the order dated 1/5/2017, passed by the Court of the Special Judge, NIA, Nagaland, Dimapur, in bail application number 29/2017, granting bail to the respondent. Oh, sir.
Mother, his name is Tapitu,
The respondent, namely
Tapitu. On the front page, mother.
namely,
At the heading, mother, your lordship, appeal,
namely, where?
mother,
Namely, Shri Tapitu, Tapitu,
Tapitu,
alias Tapi, TAPI, bracket A-13,
accused number 30.
son of Yuchutu, YICHUTU, resident of village Hor, PHOR, PS Meluri, MELLURI, district Hek, Nagaland. The learned senior counsel for the appellant submits that the learned trial court could not have granted bail to the appellant, to the respondent. Not the trial court could not have granted bail to the respondent, not to the respondent, in view of section 43D5
Of UFO.
of the Unlawful Activities bracket Prevention Act, 1967, hereinafter referred to as the UAP Act, 1967. Inasmuch as an accused person can only be released on bail if the court is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie untrue. Correct, is prima facie untrue. Full stop. He submits that the learned trial court has, however, granted bail only on considering the statement of the respondent given under section 161 CRPC.
Sure.
And has decided the bail application of the respondent in a cryptic manner. So he accordingly submits that the bail application should be the bail granted to the respondent should be cancelled. Do I give the alternative prayer? No need. So he also submits that the learned trial court, while granting bail to the respondent, had stated that the allegation for conspiracy under sections 120B IPC and 18 UAP Act has not been prima facie made up, which would prejudice the case of the
Prosecution.
appellants during the trial proceedings. So he also submits that the observation made by the learned trial court in the impugned order dated 1/5/17 as to whether the prosecution could secure the conviction of the respondent as being a member of a terrorist organization under section 20 of the UP Act after conclusion of the trial could also cause prejudice to the appellants, is it? During the trial process. He submits that the said observations should also be what? Struck off. Struck off from the impugned order dated 1/5/2017. Next para.
As well as this sentence, Mother, as such, the allegation of conspiracy under section 120B is not prima facie made out. As such, the allegation of.
Where? That I've already said. In the first part, we have not heard. We have already said that, Mr. Counsel. Okay. Next. Actually, in the very beginning, you write Mr. Senso appears along with Senso for the appellant. No one appears for the respondent. It is also noticed that while order dated 10/11/21, this court had held that since the respondent was already served notice, no further notice was required to be sent to him. Full stop. Then you write that, okay? Next. Then next para. the challenge made in this appeal against the impugned order dated 1/5/2015 is that bail should not be granted to the respondent who belongs to the NSCN
K.
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 NSCN K. So NSCN K. A banned organization. Is it a banned organization
Under schedule,
under the
schedule. Schedule of the UFA Act. Is, at
under serial number 39
39.
of the first schedule
First schedule.
to the UAP Act 1967. The case against the appellant and respondent has its genus from the FIR dated. What is the date?
My lord, that is,
Page 32.
yes, page 32.
Date
Is, date. 26/3/15. 26/3/15.
Where do you get that? 26/3/13. If I did 26/3/13. 26/3/15.
15.
26/15. Which states that on 26/3/15 at around 7 to 8 a.m. a telephonic information had been received from the SDPO Kohima. Is it Kohima? KMA means Kohima. Kohima.
Kohima.
Stating that a firing incident had taken place at IG Stadium, Kohima. The informant police official rushed to the spot for verification, where it was ascertained that 6 to 7 personnel of Bravo Company of the 19th Assam Rifle, who were waiting for a bus near the gate of IG Stadium, were shot at by persons who had come in an Alto or Maruti in one vehicle, in one silver-colored vehicle. Bracket Alto or Maruti, number unknown. Bracket close. With AK-47 rifles and pistols. The 3-4 persons who came out of the vehicle shooting at the army personnel thereafter fled the scene. During inquiry, empty AK-47 shells, 9 mm shells, and one AK bullet head and AK bullet head and 9 mm bullet head were recovered from the spot. they were only injured, correct? They were injured. Four of the Assam rifle, 19 Assam rifle personnel were injured in the incident. Yes, sir. The allegation against the respondent is that he was carrying.
He was supplying arms,
Was that he had supplied arms
arms
to the
to the NSC and
NSC and K.
K.
Yes, sir. Next para. The next para, the respondent the respondent was arrested by the police on
that he was arrested on 16. On 1/1/16.
on 1/1/60. Yes, sir. Charge sheet. No, for support. Next, before that, he was arrested before that. Just say, pursuant to the charge sheet, no, pursuant to the FIR dated 26/3/13, what was the case number registered?
Mother, may I correct it, Mother? He was arrested at paragraph 18, page 10. He was arrested on 18/12/15 from New Delhi. 18/12,
Anyway, you don't know the case number.
18/12/15.
Okay, right. Pursuant to the FIR, a case was registered.
Right.
Full stop. Thereafter, the appellants filed a charge sheet before the court of the special judge, NIA Nagaland, Dimapur, on 23/11/15.
15. And a supplementary charge sheet.
Full stop. The respondent was thereafter arrested
On
on 18/12/2015.
15.
A supplementary charge sheet was filed by the appellants on 14/6/2016.
16.
Full stop. Next para. The
Where the accused is named as accused number 13.
supplementary 46/2016, wherein the accused is named as accused number 13,
13.
bracket A13. Full stop. Next para. The respondent thereafter filed an application for bail
Bail.
by bail application number 29 of 2017. Full stop. The same was allowed by order dated 1/5/2017. Full stop. On a perusal, no, just say, section 43D5
Five.
of the UAP Act 1967 states as follows. On a perusal of the impugned order, we find that the learned trial court had come to an opinion that the allegation of conspiracy under section 120B IPC and 18 UAP Act was not prima facie made out against the respondent. It had also made an observation whether the prosecution could secure the conviction of the respondent as being a member of a terrorist organization under Section 20 of the UPA Act at the conclusion of the trial. It was on the basis of the opinion made by the learned trial court that the bail has been granted to the respondent. As next para. As stated above, the challenge to the impugned order is on the ground that the learned trial court has decided the bail application only after considering the statement of the respondent made under section 161 CRPC, and that the impugned order has been made in a cryptic manner. On considering the impugned order, we do not find anything. We do not find that there is any. We do not find that no. There on considering the impugned order, there is nothing to show that the impugned order has been made without considering the charge sheet or the supplementary charge sheet, or that it has been made only after considering the statement made by the respondent under section 161 CRPC. The above being said, we also find that we also find that 5 years and 9 months have elapsed from the date of grant of bail to the respondent. Next para. This court, by order dated 13/12/22 had directed the learned senior counsel to obtain instructions as to whether the respondent was regularly appearing and facing trial before the learned trial court. Next para, Mr. D.K. Das, the learned senior counsel, has submitted various orders passed by the learned trial court, which is to the effect that the respondent has been regularly appearing and facing trial before the learned trial court. Correct.
From the order sheet, it reflects from the order sheet, not by submission, madam.
No, what have I said? What have I said? As per the orders I've said, no?
That's not the order.
Various orders. In view of the above facts, we are of the view that no case for cancellation of bail has been made up. The bail application, the application for cancellation of bail is accordingly rejected. However, keeping in view the apprehension of the appellants, the observation of the learned trial court made in the impugned order, which is to the effect that the allegation, inverted commas, the allegation for conspiracy under section 120B IPC and 18 UAP Act is not prima facie made out, invert commas close, and invert commas, whether the prosecution can secure, just take it down from your page 108, okay? Inverted commas, two portions, okay? Should not be regarded by the trial court, by the learned trial court, as a finding made on the merits of the case at the time of disposal of the case, main case. That's all. To RI for 10 years each and fine imposed by the learned trial court will remain the same. Conviction under 303 is set aside. The period undergone shall be set off for the period of imprisonment imposed upon. The conviction under section 302 is converted to 304 part 1. And 10 years.
May I please approach? These two appeals are against the rejection
Wait,
of my
this is-
prayer for bail, madam.
This is in that day.
These two appeals
Yes.
are against the rejection of my prayer for bail, madam.
Rejecting your prayer for bail.
Bail, madam. In
By-
NIA case, madam. My lord, the charge sheet was filed and
So
thereafter
it's
I
rejecting your prayer for bail.
bail, madam.
So you're asking for bail.
I'm asking for bail. My lord, the charge sheet was
Huh?
filed.
Rejected by a trial.
My lord, the charge sheet was filed. And thereafter, I filed my bail application on merit. However, it was rejected. I came before this court, also seeking, calling for the records, madam. The lordship said the records may not be called for. They may produce the case diary. I'm told that today it could not be brought. So the case diary might be required, madam. 161 statements and other documents. They are relying against me in this matter.
Okay, so you have not brought the CD. He did not bring. So maybe he's got everything here inside. So what do? We adjourn the matter or what?
Has to-
There has to be adjourned. Can you bring the CD? Which did?
The order was on 18/2/2021.
Okay, right. Mr. B. Das, Learned Counsel for the appellants.
B. Prasad for the appellant.
Okay, Mr. B. Prasad, yes, Learned Counsel for the appellants. Submits that. The bail application submitted by the appellant before the learned trial court has been rejected by order dated
19/8/2020.
19/8/2020. So he submits that the case diary was to be produced
By order dated 18/2/2021.
by order dated 18/2/2021.
Last line, madam.
However, the same has not been produced even till today.
13th or 14th or anything. Because next week it's holiday. In the week commencing from 13th.
13th, okay, 13th? 13th, all right?
13th.
Okay, right. Mr. D. Prasad, Learned Senior Counsel, assisted by Miss G. D. Chaudhary, submits that he can produce the CD on 13th. Leaves the matter on 13th. Huh? Well, I
3 and
can't
4.
hear you, Miss.
3 and 4.
3 and 4, both 3 and 4. Order will be
Common
for 3 and 4.
Common order.
My lord, I want prayer, my lord. That's my lord. I am not well today, my lord. Let it be on Monday, my lord. Positively, I do it on Monday, my lord.
Monday, though, you'll be the only one in
I'll do
court.
it.
No one is coming.
Because
On
my
Monday,
lord,
no
I
one is
will
coming.
do
We
it.
are all going on holiday. Monday.
Oh, yes, my lord. Then, my lord. Next day, I will do it, my lord. My lord.
Oh, no, what is this? You have made a prayer earlier also.
Earlier, that is, I was not present my, because of my illness, my lord. Today, I felt well also, my lord. Only to make a prayer for to allow me for some days, my lord. I will do it. Next day, I will do it positively, my lord. I am not well today, my lord.
Huh? You're not awake.
I am not well.
You're not well.
Not well, my lord. Let it be, my lord, after a week, my lord.
You see, there is a notification issued by the registry. For adjournment, you have got to give prior notice. Prior slip has to be submitted with the consent of the other side.
No,
So
matter-
you take the second copy. You have got the
No,
copy.
no, matter before the lordship, my lord.
So, but we are bound by what the chief says. And that has been issued by the registry, by the High Court. Three zero two.
Yes, change it to me.
And let us give us the main case. Yes, madam, have you filed your written objection? Huh? Your book is ready. Acha. This is for this hearing.
Lordship for hearing, my lord. The
Yeah,
hearing
for
for all
hearing.
has come.
So this is the paper book. You see,
My lord,
then we will consider your, we have to dispose something at least.
Yes,
We'll
Lord.
dispose of your application for bail.
actually, now I am not pushing for bail, my lord. Matter is fixed for hearing, my lord. Whole
Then
matter.
So-
that application will be dismissed.
So we'll dismiss the application for bail. Then
The
we'll,
application will be pending it, yes, my lord.
huh?
But before, thereafter, my lord, matter is fixed for whole case hearing.
Correct. So
Yes, I just made it so you were.
we're dismissing the bail application.
Yes,
Heard, Mr.
and Mohammed.
SKN Mohammed,
Yes, my lord.
learned counsel for the applicants. Also heard Ms. B. Bhuyan, additional PP. This is Mr. SKN Mohammed in the IA, huh? In the IA. Mr. SKN Mohammed submits that as he's not ready for hearing on the main appeal, the IA can be disposed of. And the main appeal may be adjourned to another date. Ms. B. Bhuyan, learned additional PP, submits that she has got no objection if the main appeal is heard on some other day, provided the IA is disposed of today. The applicant has paid for bail. And for suspending the sentence under section 389 CRPC. The applicants had been convicted under section 302/149 IPC by judgment and order dated 10/2/2021 passed by the session judge, Barpita, in sections case number 23/14 and they were sentenced to undergo life rigorous imprisonment for life with a fine of rupees 10,000, in default, simple imprisonment for 6 months. There were eyewitnesses.
Yes, yes. 4 eyewitnesses.
On perusing the impugned judgment and order, we find that out of the 14 prosecution witnesses examined by the learned trial court, there were 4 eyewitnesses to the crime in question. On considering the gravity of the offense and the fact that they were eyewitness to the crime, we are not inclined to suspend the sentence or grant bail to the applicants at this stage. The application is accordingly rejected. Then in the main appeal, you write, in view of the prayer made by Mr. N. Mohammed, learned counsel for the appellant, for adjournment of the matter, which is not objected to by the additional PP, list the matter on.
Any other day?
List the matter after a week. Or do we fix a date?
Will Lordship fix a date?
When? We fix a date when?
You also made March 13, 1 3.
14.
Yes,
Okay, 13 also, no problem. 13.
Yes.
13. This is in the appeal, no? Appeal.
Lordship, Jahan is coming, madam. She is in another court. Let him start.
How long will you take?
Yesterday, I had only read out 4 witnesses for the total 13.
How long will you take?
I've got 3 more judgments, half an hour.
I know. Will you take 2 seconds, 10 seconds, 20 minutes? How much?
20 minutes,
30 minutes.
20 minutes. Oh, my lord, Lordship has single bench.
I've got single bench. That is why I'm slightly worried.
Tomorrow,
And we have got to rise at 3:15.
reference is there.
Reference is there. Okay, right. Now,
Can be a Thursday, madam.
Thursday is a
Hearing
hearing
them.
date.
okay, right. Due to paucity of time, this is the matter on Thursday.
Hurry up. Blush. 13, my lord, for a once, my lord, paragraph 16, my lord.
Page 13.
Paragraph 13.
Yes.
When I was a Lat Mondal, my lord, I was suspended, my lord. The respondents are directed to reinstate the petitioner. However, the respondents are given the liberty to transfer the petitioner to any of its office within the state of Assam, so as to serve any local or personal contact the petitioner may have and which he may misuse for obstructing the investigation against him. The respondents may also prohibit the petitioner from contacting any persons or handling records and documents. My lord.
So,
Here, my lord, I have been reinstated, my lord, and I have been transferred from that post of posting from Doboka to Lanka, my lord. Now, my lord, I have not been allowed to do work, my lord. I am sitting idle, my lord.
So,
I will be allowed to work, my lord. That much, my lord. Only that modification, because I have already been transferred. my
Where
lord.
is, no, but where is the bar?
But they, when I said, my lord, I may be allowed to work, my lord, and I am just sitting like a peon out there, my lord. No work is assigned to me, my lord.
That is a different issue. That you find a separate rate.
My lord, only my lord.
Where is the bar? From contacting or handling records and documents.
Now, my lord, as because I have the, I was transferred from Doboka to Lanka, my lord. Here, my lord, new place, my lord.
Correct.
So now hampering or tampering with the evidence doesn't arise, my lord.
No, that is a different issue.
My lord.
Now we don't know.
My lord.
You see, why you have not been given work? You file a separate rate, and you say that you say that I have not been given work. That's a different cause of action. How does this have any effect? I fail to understand.
My lord, only that part, my lord, my lord, the respondent may also prohibit the petitioner from contacting any person or handling records and documents, my lord. My lord, I am a lot.
But this has to be in relation to your DP or whatever.
DP, my lord, I have already, my lord, submitted my written statement.
Maybe, but then this is in relation to your DP. So, so is it your case that you have not been allotted work
My lord.
because they are saying that this contacting any person handling records and documents
My lord.
is they are construing it for all types of scenarios.
My lord, I am a Lat Mandal, my lord. I was in a different circle. And from that circle, I have been transferred to a new circle, my lord. My lord, only, my lord, my prayer is that, my lord, I may be allowed to work subject to their satisfaction, my lord.
That you find a separate rate.
Well, well,
Where is this? This does not lie. This does not lie. But how does it lie?
Only that
No,
modification.
no. How can we? How can we? This does not lie. This has to be read uh, with regard to the this para 16 has to be read as a whole.
My lord.
So it is with regard to the investigation
My lord.
done against you. Now, with regard to you being not allowed to work, that's a separate cause of action.
My lord, what I understand, my lord, I think, my lord, this order will be with regard to that office, my lord, that circle. And from that circle,
No, no.
I have been transferred, my lord.
Maybe, yes, whatever.
My lord.
Correct,
And then in the new circle, my lord, everything is new, my lord.
correct. So you file a case, separate cause of action. How does this? You see, the thing is that in the new circle, I don't know. There might be records which pertain to that whole circle also. I've got no idea.
It's a new circle. My lord.
It's
The
a new
problem is, my lord, these are the ACS officers, my lord. They go by the each and every word, my lord. They do not want to interpret, my lord. Nothing like that, my lord. So they have asked, my lord, the petitioner, go and modify this order. I also know, my lord. Only, my lord, that respondent may also prohibit the petitioner from contacting any person handling records and documents pertaining to that circle, my lord. That much, my lord. Pertaining the original circle, my lord. That much, my lord. That will suffice, my lord. My lord.
Okay, right. I heard Mr. N.J. Datta, the learned counsel for the applicant who submits that a clarification of the order dated 9/9/2022 passed in WPC 4891/2022 is required in as much as the petitioner has been transferred from
Doboka Revenue Circle to Lanka Revenue Circle.
the Boca Revenue Circle to Lanka Revenue Circle, in view of a pending departmental inquiry initiated against him. He submits that the applicant has submitted
The written statement.
written statement in the departmental proceeding
On 5/9/2022.
on 5/5/2022.
5/9.
5/9/2022. He submits that while this court in its order dated 9/9/2022 had reinstated the petitioner into service, liberty had been given to the respondents to transfer the applicant to any of its offices within the state of Assam, so as to sever any local or personal contact that the petitioner may have and which he may misuse for obstructing investigation against him. He further submits that the respondents were also given liberty to prohibit the petitioner from contacting any person, or handling records and documents which would have any nexus with the departmental proceeding. However, the petitioner has not been given any work in his new place of posting, even though the related work therein does not have any relation to the departmental proceeding initiated against him. Ms. Tara. I have, yes, who appears? So what do you say? The volume, sound.
Lordship, my lord, the deputy commissioner has done this everything, Lordship, my lord. I am the, my lord, the director of the revenue, DLR and.
So who appears for the
State government.
Got it.
right? Mr. J. Handik appears for the respondents number 1 and 2.
1 and 2.
I don't know how can we pass an order? Okay, Mr.
Only my lord, restraining him from only the original circle, my lord. That much, my lord. And only,
No, how?
and I think, my lord, the respondents may also prohibit the petitioner from contacting any person or handling records.
Where is the other side? We have got to hear them. We keep it like that. Next. What is this matter?
Matter relates to lordship pension, lordship family pension, lordship.
Huh?
Family pension.
Family
Was earlier
pension.
dismissed for default, lordship.
And he's and
Now this time also they have not appeared, lordship.
right, dismissing this also. No one appears for the applicant not for. From a perusal of the pleadings, it is this application has been filed for setting aside the order dated 26/11/2021, dismissing WPC number 4556/2021 for default for non-prosecuting. It is surprising that no one appears on behalf of the applicant, even though the case has been listed today. And the names of Mr. D.C. Hazarika and Ms. J. Kalita are reflected in the cause list as counsels for the applicants, counsels for the applicant. Mr. R.K. Talukdar appears for the
Respondent number 9, lordship.
respondent number 9. as no one appears for the applicant, the IA is accordingly dismissed for non-prosecution. Right, no one appears for the applicant. So this is an application paying for correction of date of death of the husband of the petitioner in the order dated 31/3/2022, passed in WPC number 1182/2022. Good stuff. The case of the petitioner is that in the order dated 31/3/2022, the date of death of the petitioner's husband was inadvertently recorded as 30/06/2030. Though the husband of the petitioner had expired on 21/6/2030. Next, full stop. As no one appears for the applicant, list the matter after 2 weeks. Yes, give me item 1. Item 1. Come to page 14. No, 13.
13, my lord, 13.
Para 16.
Lordship, para 15.
Para 16.
16. The respondents are directed.
You can read it from 15. Read it from 15.
In view of the reasons stated above, this court is of the view that the suspension order dated 1/2/22 is not sustainable beyond the period of 90 days from the date of issuance of the same. As no review for extension of the suspension was undertaken, consequently the suspension order is set aside. The respondents are directed to reinstate the petitioner. However, the respondents are given the liberty to transfer the petitioner to any of its offices within the state of Assam, so as to serve any local or personal contact that the petitioner may have and which he may misuse for obstructing the investigation against it. The respondents may also prohibit the petitioner from contacting any person or handling any records and documents.
So now the grievance of the petitioner is that he has been transferred to another circle. However, he's not been given any work.
Lordship.
So he's saying that this last portion, this respondents may also prohibit the petitioner from contacting any person or handling records
Lordship.
and documents.
Lordship.
This should be modified. I don't know how this has any effect.
No, Manoj, in a disposed of petition, IA is maintainable only for correction of typographical error. Otherwise, no IA is maintainable. He can file IA. He can very well file a review petition or other petition.
No, another aspect I was just thinking.
Lordship.
You see, these respondents may also prohibit the petitioner from contacting any person or handling records and documents
That is
pertains to the departmental proceeding that has been initiated against him.
true.
Now, the not allowing him to work, won't this be a new cause of action?
But he has been transferred to a new place. If he is not given work, I have two suggestions. If without working he is getting money, he is not even advanced. Number one. Secondly, if that is so, he can file a representation to the DC that or the authority.
I have filed.
Yeah, file.
I have filed.
DC ho jaye.
I'm fine with that.
Why do you want work? You're getting a paid holiday, as he said.
No, my lord, I was sitting like that as a peon, my lord, nothing else, my lord.
Oh, good.
My lord, they asked me to give me the
Enjoying the
file, my
money,
lord.
my lord.
No, the problem is, the problem is that is a different cause of action. There's nothing to do, there's nothing wrong with this order.
Well, I do understand. Well, only, my lord, pertaining to particular departmental proceeding or to the revenue cycle, my lord. I may not be allowed to contact any person or touch any document which relates to Doboka revenue cycle. I has been transferred to another circle, Lanka revenue cycle. There is nothing.
But how can we pass an order here? Where is it?
My lord, only that, my lord, the last line, my lord,
We can just clarify that this last sentence pertains to the departmental proceeding that is initiated against the
my
petitioner.
lord, that much.
What is it? Anna, that's only we can say, nothing else.
My lord, that much.
What have I said? Last line.
Last time, Mr. J. Henry Davis.
Appears for censor, and Mr. Deenat appears for. Mr. Deenat appears for respondent numbers. 3 and 4.
Lord,
First
3 and
one.
4.
Next, you're right. Para 16 of the order dated so passed in WPC number 4891/2022 states as follows. Let's take this. First one. The said line, the said sentence, the last sentence, inverted commas, would have to be constitute to, no, the last sentence of the said paragraph would have to be considered to be relatable to the departmental proceeding initiated against the petition.
I'm all right.
The clarification having been made, the petition, the application is disposed of.
I'm deeply obliged.
Where are all these applicants? All of them are missing, are dismissed. What is this? The next one. Right. No one appears for the applicant. This is an application for rectification of the order dated 3/2/2023, passed in WPC 13 of 2023. The applicant's case is that in the order dated 3/2/2023, this court had stated that the applicant / writ petitioner had been promoted from the post of Anganwadi helper, Rani Sundari Anganwadi Center, to the post of honorary Anganwadi worker, as per notification SWD 107/2007 81 dated 4/3/2003, while the promotion had been actually made on the basis of office order number had been made by office order number CDPO bracket S bracket close 2/2016-17 dated 1/11/2021. Further, the date of the advertisement has been mentioned as 15/11/2022. In paragraph 6 of the order dated 3/2/2023, while the date of the advertisement is actually 5/11/2022 as per Annex G of the writ petition. Accordingly, rectification of the order is required to be made. Yes, Mr. What to do? Is it correct? What?
My lord, disposing the matter. Disposing the matter.
Let us see the remove all the writ petition.
It's for rectification of the order, my lord.
Yes. Let us see. Type this.
The problem is that the writ petition is not there, so can't even.
I'll give it to you. It doesn't check at all.
Page 20 the color.
You should, you too.
My lord, I got the document.
You got, okay.
So my lord, basically what you want is that
Correction of the date.
correction of the date, that page
I think
20
this correct.
page 20, that is,
I think this correct. है ना?
yes, my
So yes, Mr. Ardhar appearing for the whom?
my lord, here. I will appear for respond number 1, 2, 1 and 2, my lord.
1, 2.
1, 2, my lord. The rest are
Are you there? 1 and 2.
BTC area, my lord.
1 and 2. Submit. Mr. Handik was there.
He is
He's
not-
not. Submit that. Submits that. Can the BTC be here?
Will to find somebody.
That's fine. Submits that. Submits that. The submit that there seems to be a typographical error in the order. Dated 3/2/2023, which needs to be rectified first of all. On hearing Mr. Ardhar, learned counsel for the respond number 1 and 2, and on perusing the annexures in WPC 13 of 2023, I find that typographical errors have been committed in the order dated 3/2/2023, passed in WPC 13 of 2023. So stop accordingly. Accordingly, the notification SWD 107/2007/81 dated 4/3/2013, which is reflected in para 1 of the order dated 3/2/2023, shall be read as office order number CDPO/S, no, CDPO bracket S, bracket close to /2016-17, dated 1/11/2021. So further, the date further, the advertisement dated, go to commas, huh? The advertisement dated 15/11/2022, reflected in para 6 of the order dated 3/2/2023, shall be read as the advertisement dated 05/11/2022. Consequently, the application is allowed and disposed of. Yes, Mr. Nayak, are you here?
Lordship.
And,
BTC, my lord.
for PTC, and Mr. P Nayak appear for Miss. So it will be Mr. Ardhar and Mr. P for 1 and 2, and Ardhar and Mr. P Nayak for
The rest.
the BTC. This is for the BTC. Huh?